All right, I think we're now ready to begin.
ORTIZ.
Good morning, and may it please the Court. My name is Rose Levering. I'm here for the appellant, Luis Ortiz. I think I'd like to reserve about 3 minutes for closing. Mr. Ortiz was charged and convicted of attempted first-degree murder and also a second count of resisting an officer with violence. The issue before you is whether it was proper for the trial court to allow the state to proceed on a felony murder theory and also to instruct the jury on attempted felony murder. The information, let me back up. There are two grounds in our argument. One is that the information charged attempted premeditated murder, did not charge specifically under the felony murder statute, felony attempted murder statute.
They did charge him with another felony, though, right?
They did. The underlying felony
resisting
was
arrest with violence.
With violence,
Okay.
correct.
And that was the one they used for the felony murder, correct?
Exactly. That was the predicate offense.
And it seems like the Supreme Court has said you can do that if you charge first-degree murder, right?
Exactly.
If you actually kill the person.
If you actually killed him, it's okay.
But if you try to kill him, it's not okay.
Exactly. And the reason for that is if you look back at the history when the attempted felony murder statute was, or that theory was codified back in 1996, that was a direct result of the Florida Supreme Court's decision in Gray. And in Gray, the court said there is no crime, this common law crime, of attempted felony murder, and made the distinction. They said that it's too much to expect that the legal fiction required to support the intent for felony murder is too great.
The verdict form specifically says, we the jury find the defendant guilty of attempted first-degree murder with a murder of a law enforcement with a firearm as charged in the information.
That is correct. The information specifically, and this was the objection that was raised at trial, the information specifically charged, not under attempted felony murder, but they charged murder, and then they charged the attempt statute. And even when they charged murder, they charged under the specific subsection which is subsection 1, that provides for premeditated design or premeditated murder. They did not charge under subsection 2, which is felony murder.
Go ahead.
Yes. No,
well, it says as charged in the information, it says guilty of attempted first-degree murder of a law enforcement, should be officer, I assume, with a firearm as charged in the information. That doesn't say that they found him guilty of felony murder or attempted felony murder, does it? It says it's charged in the information, doesn't it?
I think the problem arises is because the state was allowed to the state over objection was allowed to argue both felony murder and premeditated murder. We don't know and a general verdict form was returned. We don't know on which ground the jury returned a verdict.
Well, it says, as charged in the information, guilty of attempted first-degree murder of a law enforcement with a firearm as charged in the information. Didn't that indicate that they did not consider that it was as charged in the information rather than something that wasn't charged in the information, to wit, felony murder? But
they were instructed on both. And this was the only if they wanted to find him guilty, this was the...
Is there some obligation to object to the verdict form? In other words, if there was an objection to the instruction on felony murder, correct? Or
correct.
Attempted murder.
Yeah.
But the verdict form, you really can't tell, right? I mean, you can't tell which one they found.
Right.
But isn't there some obligation of the defense to get a verdict form so you can tell?
Perhaps, but in this case, she had already objected to the giving
of the
instruction itself.
She didn't object to the verdict form.
That's correct. She did not.
Well, I guess I'm having difficulty in this case understanding why the rule that applies to felony murders wouldn't apply to the attempted felony murder. Particularly here because there was another felony charged and murder was charged.
Exactly, and this is the difference between the common law approach to attempted felony murder and the codification. Under the common law, it was totally sufficient just to have an underlying felony. If you committed a felony and a murder occurred, you could be convicted of attempted felony murder. But when the statute was codified back in 1996, the legislature added an element, and that element was not proven. And the element that was not proven is that it's not enough to have an underlying predicate felony. You have to have a felony where there was an intentional act that is not an essential part of the underlying felony. And that is what...
Because you think the shooting of the gun was that's what supported the
That's what
resisting arrest
supported,
with violence.
exactly.
And that was also the attempted murder.
Yes.
Yeah, no, but in other words, but resisting without violence just requires a threat to the officer, correct?
Yes.
Pointing the gun would be enough. Displaying the gun, I don't know. Would that be enough?
Pointing the gun arguably would be offering violence.
Well,
but
yeah, right. Well, that's an aggravated assault.
Right.
Shooting and not hitting them is the same thing, is it not? I mean, it's an aggravated assault. If you don't hit
yes.
them, if you don't hit them.
Yes, yes. But in this case, the information did not charge the essential act, the independent act that was different from the predicate felony. And although the jury was instructed, and they were instructed, the attempted felony murder instruction tracked the language of the attempted felony murder instruction. It was not in the information, and it was not really argued. The state and the court seemed to be proceeding under the old notion that it was sufficient just that there is an underlying predicate felony. And in fact, the whole argument, as the state has pointed out, the whole argument about essential, an independent act essential, wasn't even brought up.
I guess.
Let me say also that analogizing to the robbery cases that I've mentioned in the initial brief and to the...
How is your client prejudiced by the fact that the state argued it both ways? And I guess I'm referring to the decision of Bush versus State, where the Florida Supreme Court basically said that, a party is not prejudiced by not knowing whether the state would proceed under a theory of premeditated murder or felony murder.
I'm sorry, I didn't hear
Bush
which
versus
case.
State.
Which?
Bush versus State, 461 Southern 2nd, 936. Didn't the Florida Supreme Court hold in that case that the party is not prejudiced by not knowing whether the state would proceed under a theory of premeditated murder or felony murder?
But again, that's murder and not attempted murder, and that's the distinction that I'm trying to make clear here, is that the felony murder adds an element. But to answer your question about the prejudice, it's error, and it's even fundamental error, to convict someone of a crime that's not charged in the information. And that is what may have happened in this case, because a general verdict form was returned. So we don't know under which alternative theory, and they were given both, the jury returned a verdict. And the jury might very well have been persuaded by defense counsel's argument that what she was arguing was that...
Well, if there's no prejudice in not knowing whether it's going to, the state's going to argue felony murder or premeditated murder, if there's no prejudice in not knowing that, how can it be fundamental error?
Well, for one thing, the defense... I'm sorry, how can it be fundamental error?
Yeah, I mean, didn't you say that it would be fundamental error for a person to be convicted of a crime not charged in the information?
It's a due process deprivation to be convicted of a crime not charged in information, because you're not getting the fair trial. And it appeared in this particular...
Well, if you're not prejudiced, how would it be a violation of due process then?
Well, I could analogize to being convicted of a non-existent crime, but in this case it's a crime that wasn't charged. You don't know whether the jury found him guilty of attempted felony murder or premeditated murder. They may not have believed.
Well, why aren't we supposed to take the presumption as being true that when the verdict form says, "We, the jury, find the defendant guilty of attempted first-degree murder as charged in the information," that that's exactly what they did when they specifically state that in the verdict form?
Because it's the only choice they were given. And they clearly found him guilty, but we don't know under which alternative theory. They may have bought the defense counsel's argument that this was not premeditated murder.
Okay, and as Judge Jacoba said, did the trial lawyer, defense counsel, ask for a different verdict form or propose a different verdict form?
No.
That's my whole point. So we take what the verdict form says as being true, that that's what the jury found, that as charged in the information, right?
Right. But again, that's the only way they could find. Obviously, they believed that he was guilty, but we don't know what if they believed that he was guilty of attempted felony murder, but they had guilty or innocent, so they chose guilty.
Well, they had no other choice.
Exactly.
They were going to find him guilty.
Exactly.
I have a hard time blaming the state for the fact that the defense counsel didn't ask for a different verdict form or didn't propose a different verdict form. That's the hang-up.
And unless you ask for it, we have to presume that what the verdict form says is true, and that's what the jury did in this case. Find him guilty as charged in the information. We have to presume that, don't we?
You should say no.
There is still to prove the crime of attempted felony murder. It's a specific intent crime, and you have to have the intent to do this other independent act. And if the jury believed that he was guilty, then we still don't know. If they proceeded on a felony murder theory.
I think there's a presumption that we do. I think there's a presumption that tells us that we are supposed to take the verdict form at face value if it says as charged in the information. They found him guilty as charged in the information since there was no alternative that was requested by any of the parties in this case so that the jury could say otherwise. So it seems to me like there's a presumption there that if the verdict form says that, then we presume that that's what the jury did. But you're saying that's wrong?
I'm saying I'm sorry, I'm not prepared to argue that. The state didn't raise that. It still seems to me.
Well, you're arguing that it was error for the state to be allowed to argue felony murder because it wasn't charged in the information.
And the facts don't support it.
And my question, and I asked you, well, it's really not prejudicial if you didn't know which way they were going to argue. And then second of all, the verdict form says that they found him guilty as charged in the information. There was no request to give the jury an opportunity to say otherwise. And my position is, and I think it's probably correct, that if that's the case, we presume that the verdict form is correct and the jury meant what they said when they said in the verdict form as charged in the information.
I respectfully disagree when
Okay,
it was
all right.
the only way that it was the only choice that the jury had. They still may not have, even though they said guilty, they still may not have believed that it was premeditated. And if they did not,
that requires that we speculate that they may have found him guilty of felony murder, even though the verdict form says is guilty as charged in the information. So we're supposed to speculate.
right, but there are cases also that for the theory that I'm proposing that I've cited in the brief that say if it is unsupported, if the jury relied on a legal theory which is unsupported by the facts,
the state
it's reversible.
The state in their answer brief cites Griffin versus the United States, which is the United States Supreme Court, on the general verdict form issue. What do you say about it? Does Griffin control this?
Actually, I cited Griffin in my initial brief as well,
okay.
and we have a difference of opinion here whether we've got a legal or factual decision that the jury was asked to make, and I believe that the jury was asked to make a legal decision,
okay.
not a factual decision.
That's how you distinguish.
And
Okay.
that's why I cited Griffin.
Gotcha.
All right, counsel, you have 13 seconds left.
Use
You
it
foolishly
wisely.
wasted all your time. I'm going to give you another minute beyond that.
Thank you, Judge.
To come back.
May it please the court, my name is Bonnie Parrish. I represent the state of Florida in this case. If this court has no questions,
Let me ask you, don't you think that the felony that was charged, the resisting with violence, that it was the shooting that was, I mean, that's what made it with violence, correct?
yes.
In fact, I mean, isn't that the same element that's in the attempted murder?
I would disagree. The element for resisting with violence is not shooting. It's the offer or doing violence.
I agree with you, but factually,
The
that's
fact,
what it was. Factually, that's what it was. in
right,
this
but
case.
a fact is not an element.
I see.
The fact, the act, which is not an essential element, is the shooting. And it's not under, there are some cases where the discharge of the weapon is the essential element. Resisting with violence is not, it's not that kind of charge.
The threat had to be the shooting, correct? I mean,
No, the threat, no.
I mean, in this case, factually, the threat was the shooting.
Well, in this case, the officer testified she first saw the gun in his hand, he turned and pointed it, and he kept running. He
Well,
turned the corner.
I couldn't tell that from the record. I mean,
Yeah, I thought he started shooting right off.
I thought it was
No.
when she saw the gun when he was running, but it was down by his side.
I thought she testified that he pointed at her before he went around the
I mean, you
corner.
would have to. I mean, to do that. I mean, she said she came around the corner. He was up at the apartment trying to get in. He pointed and shot at her. But I mean, it seemed like it was one. It wasn't like he pointed and then did something different.
Well, I cite pages 26, 27, and
Right.
28 in the record that when she was pursuing him on foot,
Yeah.
she saw that he had a gun, he
Right.
turned and tried to point it at her.
Then he turned and ran away.
Then he went around the corner, and she lost sight of him. And when she came around the corner, he was standing, pointing, and shot at her.
Okay.
Took off running, did it again. Resisting is, the state would like to argue that there were 3 separate acts of resisting here. But it's a continuing thing. Unless there's something that breaks it up, it's a continuing offense. But the resisting with violence could have been over and done with just when he pointed at her. You don't need the shooting.
I agree with that.
So the shooting is not an element of resisting with violence. It's a separate act, and the state would agree with the court on I could find no case law, and please believe me, I looked high and low for case law that distinguished attempted first-degree murder from a first-degree murder. The issue on the information wouldn't be an issue if he had been successful and killed the law enforcement officer. But because he didn't, they've tried to create an issue. There isn't anything to say that the same logic doesn't apply, the case law that applies to murder cases to attempt first-degree murder cases.
I think in the abstract that's probably correct. The problem is the statute does seem to call for the additional element that we would not ordinarily find in felony murder. And that, I mean, it's troubling. It seems to me that the logic of it is that it's good for felony murder, it's good for attempted felony murder. But the statute threw in another element, and so we have to consider that.
But the other element, it's not another element. The attempted felony murder statute was created in response to Gray.
Yes.
To get rid of the legal fiction of it's the same crime. You still have to have an act that could have caused the death but didn't.
And an underlying felony.
You have to have an underlying felony.
So he could have been, I mean, the underlying felony could have been a burglary.
It could, but then you would need an act.
And then he could have shot at her, could have shot at the police officer as well. I mean, then you have a pretty clear case of it.
Right. I don't think, that's just a different crime. I don't think it makes it any different in this case. And if this court...
I'm not so sure, but that's an interesting theory.
If the court has no other questions...
Now let's get Ms. Levering back here for 13 seconds.
Thank you. I'd ask that you affirm the conviction in this case.
13 seconds.
I'm going to give you a minute and 13 seconds.
Thank you. Okay. Very quickly, by the same token, there are no cases supporting the state's position. And if you look at, as regards the separate element, if you look at the robbery line of cases, if you look at if I'm pronouncing it correctly, Kwaku case that went up to the Florida Supreme Court, they found there was a very similar case. It was a robbery, there was a shooting. The DCA found that the shooting was not a separate intentional act. And I would just argue that we have the same situation here.
That was the 4th District case?
Pardon me?
That was the 4th District case?
I believe it was 3rd District.
3rd District?
Right, right.
Okay.
And the Florida Supreme Court did not disturb that finding.
That's true.
Right?
That was it.
Right. The actual, the only thing the Supreme Court ruled on was when the district court tossed out the attempted felony, first-degree felony murder cases, whether it was proper to reduce it to a second-degree felony. That was the only issue that the Supreme Court decided, although they certainly could have decided the separate incident.
Thank you very much. That's a well-argued case.
Very, very good.